Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to UCAN. It is an initiative where our endeavor is to comprehensively cover current affairs subject-wise. In today's session, let's cover polity-based current affairs, and we will cover current affairs of the period 17th October to 7th of November 2024. What are the topics that we shall be covering today? 6 topics in total. Number 1, taxing industrial alcohol, a judgment given by the Honorable Supreme Court. And this has been picked up from the Indian Express and the Hindu. Then, whether private property is a material resource of the community, another important judgment of the court. That's also something that we will discuss. Then the strike at Samsung unit in Tamil Nadu, which we have picked up from the Frontline magazine, an important topic when it comes to governance. For example, in governance, one of the topic is pressure groups, so on and so forth. Then another article, an opinion column written in the Indian Express by Professor Yogendra Yadav, where he is calling for junking the Model Code of Conduct. Why? We will understand. The 5th one, the Supreme Court has upheld the validity of the Uttar Pradesh Madrasa Act. What does that law mean? What are the implications? That's something that we will discuss. And towards the end, we will focus on the anti-defection case in Goa, because the Goa Legislative Assembly Speaker has ruled in favor of the defectors. This matter will go to the Supreme Court. Now, exactly what will happen, that we will have to wait and watch. So these are the 6 topics that we shall be discussing in total. And remember, the judgment of the court in Aligarh Muslim University, which appeared in today's newspaper, we will cover in a different UCAN session. Okay? But before we start, an important announcement. If you are not aware yet, tomorrow at 11 o'clock in the morning and then again at 5 o'clock in the evening, Unacademy is conducting India's largest scholarship test. And if you score well, you may end up winning a prize ticket to watch the Border Gavaskar Trophy, a cricket test match between India and Australia. If not, then you can end up getting an all expenses paid vacation at a 5-star hotel. If not, then you can end up getting iPhones, MacBooks, tablets, smartphones. And if you wish to enroll in our learning programs, you can get up to 90% discount in the subscription fee. That's something that I've been told, and you will end up getting scholarships from the pool worth 50 crore rupees. So please register for the scholarship test. There is no reason why you should skip this test. Even if you are thoroughly prepared for this exam, you can still analyze your own performance by attending this test. Clear? And if you're liking our initiatives, do not forget to press the like button and subscribe to our channel if you haven't yet. And if you want the access to the PDF that I will be using in this lecture, that shall be available on my Telegram channel. Please follow that channel to get access to the PDF. Let's get started and let's look at topic number 1, taxing industrial alcohol. In July this year, another 9-judge bench of the Supreme Court ruled in favor of the states. That states, you have the power to charge royalty on mines and mineral-bearing lands. That's something that we have covered in one of the UCAN sessions. That judgment was widely viewed as a judgment which strengthens fiscal federalism in India. That was also a judgment given by 9 judges of the Supreme Court, and in that judgment also, Justice Nagaratna had dissented. Now, what has happened in this case? A 9-judge constitution bench of the Supreme Court, again held by a majority of 8:1, Justice Nagaratna again dissented, saying that the states do not have the power only to tax the alcoholic liquor which is used for human consumption, but states also have the right, the power to tax industrial alcohol. This is considered to be another significant judgment which strengthens fiscal federalism in India. What was this case? Why did the judges rule in favor of the states? Why did this case reach the Supreme Court in the first place? Why did Justice Nagaratna dissent in this case? That's something that we will understand now. But before we start, a quick look at the entries in the 7th schedule of the Constitution. If you are not aware of these entries, it becomes difficult for you to understand this topic. Article 246, which provides for 7th schedule of the Constitution, talks about distribution of legislative subjects into union list, state list, concurrent list. Who has the power to make laws on union list? Parliament. Who has the power to make laws on state list? State legislatures in normal circumstances. Who has the power to make laws on any item mentioned in the concurrent list? Both Parliament as well as the state legislature. But if there's a clash between the law passed by the Parliament on a concurrent item and the laws passed by the state on this item, it's the parliamentary law which prevails. Unless, if that state law has received the assent of the president, then for that particular state, it is the state law which prevails. That's something that you're aware of? Right. When it comes to Schedule 7 of the Constitution, if you look at the List 2, state list, it explicitly provides power to the state legislature. The dear state legislature, what you can do, you can impose tax on intoxicating liquors. That means you can regulate the sector, which also means that the production of this intoxicating liquor, the manufacture, the possession, the transport, the purchase, the sale of these intoxicating drinks, that comes within the domain of the states. Clear? Yes. Then there is Union List, State List 1. Union List, entry number 52. What does it state? If Parliament passes a law saying that their union, their central government, it is in public interest that this industry you should regulate, union will have the power to regulate that industry. And this industry can be what? It can be any industry. If the Parliament passes a law saying that union, you have the power that you should control this industry because it is in public interest. Now that industry will be controlled by, regulated by the union, which means the center. And using this entry 52 of the Union List, Parliament enacted a law in 1951 called Industries Development and Regulation Act of 1951. And under this law, industrial alcohol was regulated by the union. Okay, let's look at something else. Concurrent list, list 3, entry 33. It says trade and commerce in and the production, supply and distribution of products. Products of what? Any industry. If Parliament passes a law saying it is necessary in public interest that union, you should regulate this product of this industry, then on this item, on this product of this industry, who has the power to make law? Both Parliament as well as state legislature. But sir, don't you think that entry 52 of Union List and entry 33 of concurrent list more or less is the same? But if you have attended my lectures, you would recall that it was this entry 33 of the concurrent list which was used by the Parliament when Parliament enacted the 3 farm laws. Because this entry 33 of the concurrent list, it gives power to the Parliament as well as the state legislature that what you can do, you can regulate trade, commerce, production, supply, distribution of the products of any industry. If Parliament has enacted a law saying it is in national interest, it is in public interest that you should regulate this industry. But you would also know that this was meant to be a temporary arrangement. This was meant to be within the control of the power of the Parliament only for 5 years from the commencement of the Constitution. What are we trying to say? Trade and commerce in production, supply and distribution of the products of any industry. This was meant to be given the power to the Parliament as well as the state legislatures only for 5 years. Why? Because at the time of the commencement of the Constitution, India was not self-sufficient in food. There were some states which were self-sufficient in food, producers of food grains, but other states were not. How can the center ensure that these food grains, food items are distributed throughout the country? For that, Parliament was given the power by the Constitution that for 5 years you can regulate agriculture or food-related items. But what was meant to be temporary, only for 5 years from the commencement of the Constitution, became permanent when the Constitution was amended. The third Constitutional Amendment Act was passed. This is something that we have discussed when we discussed the 3 farm laws. But let's come back to this topic. Sir, what is this industrial alcohol? That's the question that can be on your mind. Industrial alcohol is basically impure alcohol. For example, ethanol, which is prepared by fermentation of food, molasses, so on and so forth. If this ethanol is mixed with, let's say, benzene, then this ethanol becomes denatured ethanol. Denatured ethanol. And this denatured ethanol is what is known as the industrial alcohol. And this industrial alcohol is used for the manufacturing of perfumes, pharmaceuticals, medicines, so on and so forth. What are we trying to understand? Taxing industrial alcohol. A 9-judge bench of the Supreme Court ruled that states have the power not only to tax alcoholic liquor, alcoholic beverages, alcohol used for human consumption, but also industrial alcohol. For that, you need to understand what is industrial alcohol. Industrial alcohol is basically impure alcohol. For example, ethanol, when it is mixed with benzene or pyridine, what happens? It becomes denatured. This process is called denaturation, and ultimately it becomes industrial alcohol. And this industrial alcohol is used in various industries for the manufacturing of pharmaceuticals, for the manufacturing of perfumes, for the manufacturing of cosmetics. And this industrial alcohol was regulated by the center under this Industries Development and Regulation Act 1951. Why? Because according to entry 52 of the Union list, of list number 1, industries, the control of which Parliament says should be given to the Union in public interest. And it is this section, it is this entry 52, which was used by the center to control, to regulate industrial alcohol. State said, but under entry 8, we have the power to tax, to regulate intoxicating liquor. So this should ideally come within the domain of the states. So which means we should have the power not only to tax alcoholic liquor for human consumption, but also industrial liquor. What happened? A judgment was given by the court, by the Supreme Court in 1990 in Synthetics and Chemicals Limited versus State of Uttar Pradesh. And Supreme Court in that case, the 7 judges of the Supreme Court had ruled that states have the power only to tax intoxicating liquor. That means this liquor which is used for human consumption, potable alcohol. States do not have the power to regulate, to tax industrial alcohol. Why? Because this industrial alcohol comes under the domain of the Parliament, the domain of the Union, because of the 1951 law, because of the entry 52 of the Union list. Then what happens? The year was 1999. Uttar Pradesh government imposed a license fee of 15 paise per liter of this industrial alcohol. What Uttar Pradesh government did? Imposed a license fee. How much? 15 paise per liter of the industrial alcohol. Why? Because the Uttar Pradesh government said that this industrial alcohol, it can also be used, listen to me carefully, this industrial alcohol can also be used to manufacture illicit liquor. And this illicit liquor is also used for human consumption. That is what illicit liquor also leads to death of the people, and you might have witnessed news stories that after consuming illicit liquor, people have died in Bihar, in Tamil Nadu, and other parts of the country. So the states argued that we need to regulate this because industrial alcohol is not only used for pharmaceuticals, for manufacturing cosmetics or perfumes, it can also be used for manufacturing illicit liquor, which can be used for human consumption. That is why we need to regulate. This notification of the Uttar Pradesh government was struck down by Allahabad High Court in 2004, saying, no, you don't have this power. Why? Because Allahabad High Court relied on this 1990 judgment of the Supreme Court in Synthetics and Chemicals Limited versus State of Uttar Pradesh, saying states have the power to tax intoxicating liquor for human consumption, not industrial alcohol. Then Uttar Pradesh government approached the Supreme Court. And not only Uttar Pradesh government, there were other state governments which also approached the Supreme Court. And they drew the attention of the Supreme Court to another case called Chaudhry Tikka Ramji versus State of UP in 1956. These states argued before the court that, my lord, when in 1990, a 7-judge constitution bench of the Supreme Court gave this verdict, nobody pointed out another Supreme Court judgment of 1956. Supreme Court said, what was this judgment? The petitioner said that, my lord, in this case, Uttar Pradesh government had tried to regulate the supply of sugarcane. And the union government had said, you don't have this power. Why? Because it comes under entry 52 of union list. And any item which is under entry 52 of the union list, who has the power to regulate? Center. Supreme Court said no. On this matter, it does not come under entry 52 of the union list. It comes under entry 33 of concurrent list, which means state legislature also has the power to regulate matters when it comes to sugarcane. Why? Because that is explicitly mentioned under entry 33 of the concurrent list. Long story short, the Uttar Pradesh government and various state governments which intervened in this case, because after all, tax on alcohol is one of the biggest sources of revenue for a state. In fact, if you ask somebody in Karnataka and somebody is traveling to Delhi, this guy from Karnataka would ask the guy coming from Delhi that please bring liquor bottles from Delhi to me. Why? Because in Karnataka, liquor is expensive. Why? Because the Karnataka government has imposed additional excise duty on consumption of alcohol. Why? Because consumption of alcohol, tax or excise duty on alcohol is one of the big sources of revenue for a state. That is why it has been kept out of GST as well, because it is one of the primary sources of revenue. And because of this judgment now, because it strengthens fiscal federalism, it gives more power to the states to generate their own revenue, because these states were complaining that we lost revenue because of the implementation of the GST. Now that is how it is going to further strengthen fiscal federalism. But be that as it may, let's come back to this judgment. Uttar Pradesh government and various state governments which intervened in this case, they said that their Supreme Court, when in 1990 you gave this judgment, you did not rely on or you neglected or ignored this 1956 judgment of Tikka Ramji versus State of UP, where this power was given to the states as well to regulate sugarcane. Same way, you should give power to tax industrial alcohol to the states as well. And now the matter was to be decided by a 9-judge bench of the Supreme Court, because the previous judgment was given by 7 judges. What did the Supreme Court rule? Justice Chandrachud, Chief Justice of India, who wrote this judgment along with 7 of his colleagues, because 8 judges were in favor, Justice Nagaratna dissented. The majority opinion of the Supreme Court was, when it comes to entries in the 7th schedule of the Constitution, these entries should be given wide interpretation. Wide interpretation in the sense that it should cover ancillary items as well. It should cover incidental items as well. For example, when we say liquor, that does not only mean intoxicating liquor, that can also mean industrial liquor as well. Justice Chandrachud said, listen to me carefully. This is a liquor. Constitution uses three different phrases for alcohol. Alcoholic liquor for human consumption, intoxicating liquor, intoxicating drink. These are the three different variants used for alcohol under the Constitution. Because under state list, it is absolutely clear that who has the power to tax alcoholic liquor for human consumption? It's the power with the states. Just as Chandrachud said, liquor can be used to make somebody in an inebriated state. You're not sober. And this liquor can also be used as an intoxicant. Intoxicant in the sense, poison. Listen to me carefully. There is ethanol, which is used for human consumption, right? Then there is industrial alcohol, because this ethanol is mixed with benzene, pyridine, so on and so forth, which makes it impure alcohol, which is not fit for human consumption. But this industrial alcohol can also be used for making illicit liquor, which is a poison, which can be an intoxicant, which means it will have an impact on the public health. And public health is the domain under state list. And Supreme Court majority opinion said, if there are two interpretations possible, industrial alcohol, two interpretations are possible. One is that it comes under entry 52 of the union list. Another interpretation is that no, it comes under state list. If there are two interpretations possible, then we have to give effect to that interpretation which strengthens or which maintains federal balance, because federalism is part of the basic structure of the Constitution. And that is why Supreme Court ruled that we have to give a wide interpretation to this. Intoxicating liquor, alcoholic liquor, industrial alcohol, this comes under the domain of the state. Because if we give interpretation to this aspect, it is going to strengthen federal balance and ultimately benefit the states. Justice Nagaratna dissented. She said, although center cannot regulate, impose a tax on intoxicating liquor, but states do not have the power to impose tax on industrial alcohol. Because what is the focus? The focus has to be on the product consumed. Industrial alcohol is used for various industries, which comes under the domain of the union. As such, it should not be given to the states. You're going to violate or you're going to deregulate this entire system. But be that as it may, this is one of the landmark judgments of the court. By a majority of 8:1, the Supreme Court ruled that states have the power to impose taxes not only on alcoholic liquor for human consumption, but also for industrial alcohol as well. This covers our topic number 1. Any questions on this particular topic? Anyone? If you have understood this topic, give me a thumbs up. Okay. Let's look at topic number 2. Whether private property is a material resource of the community. How this matter reached the Supreme Court. Listen to me carefully. When we look at Bombay is basically, or should we say originally, a group of 7 islands. These 7 islands were merged together in a series of land reclamation projects. And because of these series of land reclamation projects, we have the current city of Bombay. But then Bombay also became the center of the textile revolution in India. People started migrating from different parts of the country to Bombay, which means when more people enter a city, you need infrastructure, which means you need accommodation. One, because of these 7 islands merged together to create Bombay, there was always the shortage of land in Bombay. Governments were given the power that you should reclaim more lands and construct accommodations, flats, and provide accommodation to the people. Even this was not sufficient enough. On top of that, some of these buildings, or a large number of these buildings, were in a dilapidated condition. Monsoon would come, rains would lash different parts of Bombay, and some of these buildings which are unfit for residents would collapse as well, leading to the destruction of these properties, leading to the deaths of individuals as well. Multiple initiatives were taken. Initiatives such as cess will be imposed. Why? Because how do we maintain this building? How do we conduct the periodic maintenance of this particular building? On that, cess will be imposed. This cess will be imposed on the owners of these buildings as well, and a part of the cess will be imposed on the tenants as well. Even then, it could not happen. Even then, these buildings would collapse because these buildings, a large number of these buildings, were unfit for residents. Then how do we deal with this problem? This is where, or this case, you should know, the title of this case is Property Owners Association versus State of Maharashtra 2024. Again, a 9-judge bench of the Supreme Court is giving the verdict in this case. Justice Nagaratna is partially agreeing with this verdict. Justice Dhulia has given his dissent, but other judges were in favor of this verdict. The case name is Property Owners Association versus State of Maharashtra, one of the oldest cases which was pending in the Supreme Court. What was the background? The background was Bombay. And when all of this was happening, the legislature of Maharashtra, after the independence, in 1976 passed a law called Maharashtra Housing and Area Development Act of 1976. This act was amended through an ordinance in the year 1986. What happened because of this ordinance? Listen to me carefully. Acquisition of this cessed property for cooperative societies of occupiers. Sir, what are you trying to say? Shortage of housing in Bombay. On top of that, old buildings in dilapidated conditions, not fit for residents, and these buildings will also collapse unless and until periodic maintenance is conducted for these buildings. For that, series of initiatives were taken. Cess was imposed, nothing happened. Government tried to regulate, nothing happened. Then the government said, we need to do something else. What? We will pass a law called Maharashtra Housing and Area Development Act 1976. We will not go too deep into the details of this law, but we will specifically focus on the amendment to this law, which was made via an ordinance in 1986. And because of this amendment, what happened? Now this property, which is a cessed property, because on this property, cess was imposed. This property, the owner was someone else, occupier was someone else, tenant, owner is someone else. Now this cessed property can be acquired by the state and can be given to a cooperative society. How? If 70% of the occupiers of this building make an application to this effect. So the tenants who are occupying these buildings, 70% of them will make an application saying we want to transfer this property to a cooperative. Not the owner. Owner will lose access to this property. It will be given to a cooperative society. This cooperative society will now maintain this building. The owners of these buildings, they approached the court saying this is violative. Violative of what? This is violative of Article 14 of the Constitution. Right to equality. They said this law is specifically applicable to the properties in Mumbai and not other parts of Maharashtra. So this is discriminatory against the property owners of Mumbai. As such, it violates Article 14 of the Constitution. And at the same time, this is a private property. How can this private property be acquired by the state? And why it should be acquired by the state? And for that, you need to understand two important directive principles of the state policy. Directive principles of state policy, which you would know are not enforceable in a court of law, but Article 37 talks about two important characteristics of directive principles. Number one, these are not enforceable in a court of law. Number two, nevertheless, it shall be the duty of the state to implement this DPSP, because these DPSPs are fundamental for the governance of the country. Two such DPSPs, Article 39B and 39C. Article 39 Clause B says, the state shall endeavor that the ownership and control of the community's material resources should be so distributed so as to subserve the common good. And 39C says, no matter what economic system you use, it should not result in the concentration of wealth to a common detriment. It should not result in the concentration of wealth in fewer hands. It was this Article 39 Clause B which was invoked by Maharashtra legislature, saying we are also state under the meaning of Article 36, because Part 4 of the Constitution starts with the definition of the state under Article 36. So we have to implement these DPSPs, and for that these buildings are resources of a community. And when these are resources of the community, they are to be so distributed to a cooperative society to subserve the common good, to serve the good of the people. You need to understand something else. Article 31 capital C, which was added to the Constitution by 25th Constitutional Amendment Act 1971, when Shrimati Indira Gandhi was the Prime Minister. This Article 31 capital C said, if Parliament passes a law, if the state enacts a law to give effect to these two directive principles, and in the process it violates Article 14, 19 and 31, because at that time right to property was still a fundamental right, the law cannot be declared unconstitutional merely because it violates three fundamental rights. This was for the first time that Parliament tried to give primacy, superiority to two directive principles over three fundamental rights. Because previously the position was fundamental rights are superior, directive principles are inferior. But when this constitutional amendment was made in 1971, Article 31 capital C was inserted into the Constitution. This Article 31 capital C said, if the state enacts a law to give effect to these two directive principles, 39B and 39C, and in the process it violates Article 14, 19 and 31, the law cannot be challenged on this ground. Further, listen to me carefully. This constitutional amendment also said that such a law cannot be challenged in any court of law. That means such a law is immune from judicial review. Matter went to the court. Which was that case? Keshavananda Bharti versus State of Kerala, 1973. Supreme Court upheld this constitutional amendment. 13 judges of the Supreme Court upheld this constitutional amendment, saying this constitutional amendment is valid, except you can't say that this law cannot be challenged because judicial review has to be there. There is something called basic structure. Although judicial review as part of the basic structure, it was given by the Supreme Court in another case in 1980 in Minerva Mills case, which I'm going to tell you now. But then emergency was imposed. And during emergency, this Article 31 capital C was amended again. Now this time, listen to me carefully, this time Parliament said if state wants to give effect to one or more DPSPs, previously it was only two DPSPs, 39B, 39C. Now the Parliament is saying, if the state wants to give effect to one or more DPSPs, that means all DPSPs were given superiority over three fundamental rights, 14, 19 and 31. Even this constitutional amendment was challenged before the court, and this case was Minerva Mills, 1980. Supreme Court said this is unconstitutional. Why? Because there is harmonious relationship between directive principles and fundamental rights. And by giving primacy, superiority to all the DPSPs over three fundamental rights, you're disturbing this harmonious relationship, which is part of the basic structure of the Constitution. And it was in this judgment that Supreme Court declared judicial review is also part of the basic structure of the Constitution. So this seems very convoluted and confusing. Can you recap? I will. What is this case? Property Owners Association versus State of Maharashtra 2024. 9 judges are hearing a case. What is the background of this case? A law was passed in 1976 in Bombay. This law was amended via an ordinance. This law basically said that this property on which cess has been imposed can be acquired by the state, transferred to a community, and then this cooperative society will maintain this property, maintain this building. Why? Because this property is the material resource of a community. And when this is a material resource of the community, it has to be distributed in such a way that it leads to larger public good. It leads to common good. The owners of this property, they challenged this in the court, saying this is unconstitutional. Why? Because you're violating Article 14. Why is this law applicable only to the residents, to the properties in Mumbai and not other parts of Maharashtra? And how can you say that a private land or a private property is the resource or material resource of a community? And to understand this, we need to understand Article 39B, Article 39 Clause C. 31 capital C, this article which was inserted in 1971, it said, if the state is implementing 2 directive principles, even if it violates 3 fundamental rights, don't worry. Merely on this ground, the law is not unconstitutional. And in fact, you cannot even challenge this law in any court of law. Matter went to the court in Keshavananda Bharati. Supreme Court said 31C is constitutional. Yes, you can give superiority, primacy to 2 directive principles over 3 fundamental rights. But there will be judicial review. Emergency is imposed. This article is amended again, 31 capital C. Now this time, Parliament is giving superiority to all DPSPs over 3 fundamental rights. Not just 39B and 39C. If Parliament, if the state wants to give effect to 1 or more DPSPs, and in that process you are violating Article 14, 1931, the law cannot be declared unconstitutional on this ground. This constitutional amendment was challenged in the court in Minerva Mills, 1980. Supreme Court said it is unconstitutional. Because there is a harmonious relationship between directive principles and fundamental rights. You're trying to disturb that harmonious relationship. As such, it is unconstitutional. This is where an important concept comes into the picture. One of the lawyers in this case was Falias Nariman. Unfortunately, he has died now. When he approached on behalf of these Bombay Housing Owners Association, when he approached the Bombay High Court, he spoke of something called doctrine of revival. What is this doctrine of revival? Listen to me carefully. This is 31C in 1973. This is 31C in 1980. (31C in 1973, 31C in 1980. What is 31C in 1973 after the Keshavananda Bharati judgment? That yes, 39B and 39C will have superiority over 3 fundamental rights, 14, 19 and 31. What is this 31C in 1980 after the Minerva Mills judgment? Because you had said 1 or more directive principles, they will have superiority over Articles 14, 19 and 31. Clear? Look at the beautiful point. If this has been struck down in Minerva Mills case, does that mean automatically the 31C of the past will be revived? Falias Nariman says no. Why? Because this doctrine of revival applies to ordinary laws, not constitutional amendments. Since 31 capital C, its modification was done by a constitutional amendment, and this modification has been declared unconstitutional in Minerva Mills case. That means 31 capital C in its entirety is unconstitutional. It will not be revived to 31C of 1973, where 39B, 39C will have superiority over 3 fundamental rights. That cannot happen, because doctrine of revival applies only to ordinary laws, not to constitutional amendments. Who says this? Falias Nariman. But ultimately it is an argument. It's for the courts to decide whether we will agree with your argument or not. But this was the beautiful argument given by Falias Nariman. And that is how this challenge went to the court. Saying now, since 31 capital C has been declared unconstitutional in 1980, which means now even if you are implementing 39B, you still cannot violate Article 14. Now, there were a couple of questions, 2 critical questions that the court had to answer, that this 9-judge bench of the Supreme Court had to answer. Question number 1, this 39 clause B, which says the material resources of a community should be distributed so as to subserve the common good. Whether this phrase, material resources of the community, can also include privately owned property. Which means tomorrow, your bank balance, your jewelry and ornaments, your cars, your land, your property can also be acquired by the state and distributed so as to subserve the common good. This is what we call socialism. Question number 1. Question number 2, whether the laws which are passed by the state to implement directive principles of state policy, to implement 39B, whether it is exempt from legal challenges based on fundamental rights violations. Which means what will prevail? The position of 31C in 1973? Or as what Falias Nariman is saying, that there is no doctrine of revival when it comes to constitutional amendments acts. Doctrine of revival applies only to the ordinary laws. In fact, this matter had gone to the court once in 1977 in another case called Ranganatha Reddy versus State of Karnataka, in which a dissenting judgment was given by Justice V.R. Krishna Iyer. And Justice V.R. Krishna Iyer had said that even a private property can be acquired by the state, because even this private property is a material resource of a community and can be so distributed so as to subserve the common good. But it was a minority judgment. It was a dissenting judgment. But it was this minority judgment of Justice V.R. Krishna Iyer which was relied by the court few years later in Sanjeev Koch case in 1982, where the Supreme Court said it is basically V.R. Krishna Iyer's dissenting judgment which is the real law, so we will abide by it. So what was the minority opinion in 1977 case of Justice V.R. Krishna Iyer became the majority opinion of the court in 1982 in this Koch case. Again, this argument of Justice V.R. Krishna Iyer was relied upon by another Supreme Court case, Mafatlal Industries versus Union of India in 1997. Sir, what are you trying to say? I'm trying to say that in 1977, the minority opinion given by Justice V.R. Krishna Iyer that even the privately owned properties are the material resources of a community, as such can be distributed so as to subserve the common good. This minority opinion of 1977 became the position of the Supreme Court in 1982, then again in Mafatlal case in 1997. So this is the law of the land, because any judgment given by the court under Article 141 becomes the law of the land. And now this 9-judge bench of the Supreme Court had to decide what is the current situation. First, does the phrase material resource of the community include privately owned property as well? All the judges are saying theoretically yes. Theoretically yes. But when it comes to ornaments, when it comes to jewelry, when it comes to cash, that will not come under the material resources of a community, as such cannot be distributed for larger good. In fact, on this matter, Justice Nagaratna also agrees. But there was a big controversy. And what was that controversy? Normally, when there are 9 judges which are hearing this matter, I as a judge will have my opinion. Others will have their own opinion. So if my opinion matches the opinion of other judges, then we decide who will write the judgment. So you write on my behalf, I will write on your behalf. So on and so forth. So you circulate it. You circulate your opinion. Then ultimately they sit together, they discuss, and ultimately come to the conclusion what is going to be the verdict of the court. In this case, something was circulated by Justice Chandrachud and other judges. And they had allegedly criticized V.R. Krishna Iyer's doctrine, saying this is the dogma of the past. This reeks of the one side of economic philosophy. Constitution is an organism, is an organic document. It keeps on changing. So we should not apply the old doctrines which were relevant then, now. So Justice V.R. Krishna Iyer is speaking one language of socialism, which has done a great disservice to the Constitution. A very strong word to use. And this is where Justice Nagaratna and Justice Dhulia, the other judge, they disagreed with Chief Justice. Although, just to be factually correct here, this strong language which was used in that draft, it is not present in the final verdict. But it is alleged that this was circulated amongst the judges. And Justice Nagaratna, Justice Dhulia, they're saying, how can you criticize the judges of the past? Because they are giving judgments in their own time, related to the peculiar situation of that time. So the judgments of the past judges cannot be criticized by judges of the future who are living in different economic conditions altogether. Because after Justice V.R. Krishna Iyer, liberalization, privatization, globalization took place in 1991, where the economy changed. But be that as it may, the majority of the judges agreed, saying no, and all the private property is not the resource of a community, material resource of the community. But whether the state can acquire this private property, that will depend on case-to-case basis. Which means this judgment strengthens judicial review. That means even tomorrow, if the state wants to acquire private property, the courts will have the power to decide whether it is indeed the material resource of a community. For example, the court said airwaves, spectrum, can be viewed as material resource of a community and has to be distributed so as to subserve the common good. Private property, for example, land in excess of the ceiling can be viewed as material resource of a community and distributed for the common good. Long story short, this case, which raised 2 questions: whether every private property can be viewed as material resource of a community. Supreme Court by the majority said not all private property can be acquired by the state. It will vary from case to case basis. We have to see what is this property. And what is the implication of this property? In a sense, what is the characteristics of this property? Whether this property can be used for larger public good or not. Maybe this property can be used for the construction of a hospital, university, laying down public roads. Then it can be viewed as the material resource of a community, because from this property, the community will be benefited. And this is where the concept comes, doctrine of eminent domain. Any property which has a larger impact on the public, which can be used for larger public good, the state has the power to acquire that property. Doctrine of eminent domain. But not all private property. This is the big takeaway from this judgment. Not all private property is the material resource of the community. Why this had to be clarified? Because V.R. Krishna Iyer minority judgment was relied upon in Sanjeev Kok case, then again in Mafatlal case, to say that all the private property is the material resource of a community, as such can be acquired by the state. Now that judgment, that view of the court has been done away with. Not all private property, but yes, some private property can be acquired by the state for the larger public good. And second, whether a law which is designed to fulfill Article 39 Clause B or 39 Clause C, whether it can be challenged on the grounds that it violates fundamental rights? Yes. Because there is doctrine of revival, which means if 39 Clause B and 39 Clause C, they were given primacy over for Articles 14, 19 and 31 in 1973. But in 1976, all DPSPs were given superiority over 3 fundamental rights. And in 1980, the Supreme Court said this is unconstitutional. That does not mean that now 31C is not present, because 31C will be revived basis 1973. So 39B and 39 Clause C will have superiority over Article 14, 19 and 31. But this law, if it is passed by the state to give effect to these 2 directive principles, it can be challenged on the grounds that it violates other fundamental rights. Clear? But Justice Dhulia, he heavily criticized, he was against this argument. He said, no, all the private property is the material resource of a community and can be acquired by the state and distributed so as to subserve the common good. Why? Look at his reasoning. He said, Justice Krishna Iyer doctrine, or for that matter, Chief Justice Chinnappa Reddy doctrine, because it was the Chief Justice Chinnappa in 1982 in Sanjeev Kok case who relied on Justice V.R. Krishna Iyer's minority verdict to say that all private property is the material resource of a community. Justice Dhulia is saying that Krishna Iyer doctrine and Justice Chinnappa Reddy doctrine is familiar to all who have anything to do with law and life. He says, this view of Justice Chinnappa and V.R. Krishna Iyer is based on the humanist vision of the society. This is the doctrine which has illuminated us, given us light in dark times. This is a doctrine which provides us with empathy for the poor. And this is going to be our judicial philosophy. Justice V.R. Krishna Iyer had said, look at this beautiful line, the courts too have a constituency, the nation. And the courts too have a manifesto, which is the Constitution. So basically, Justice Dhulia is saying V.R. Krishna Iyer's argument is valid even today, which means all private property is viewed as material resource of a community. But the other judges disagreed, saying not all private property, which means if you want to understand the big significance of this judgment, it strengthens judicial review. Because tomorrow, if the state acquires property and distributes it, the courts will have the power to challenge, to review that, and decide whether it is a material resource of a community or not. So that clarity we have received because of this 9-judge judgment of the Supreme Court. That completes our topic number 2. Any questions as of now? When DPSPs are not binding, then why state is doing? DPSPs are not enforceable in a court of law. That doesn't mean DPSP should not be implemented. The very reason why DPSPs were not given enforceability was that the state needs time and resources to implement it. That does not mean that DPSPs are inferior to fundamental rights. Those who understood this topic, give me a thumbs up. Yes, no true and false here. Let's look at another topic. Topic number 3, strike at Samsung unit in Tamil Nadu. The workers of Samsung Electronics unit in Sriperumbudur district in Tamil Nadu, close to 50 kilometers from Chennai, they went on a fast, they went on a strike, and this strike lasted for 38 days, which is considered to be one of the longest running strikes in the recent years. Previously, workers at the Royal Enfield unit, they also went on strike, which lasted close to 50 days. This topic has been picked from the Frontline magazine. But why were the Samsung workers on strike? They basically wanted better wages, better working conditions, but most importantly, they wanted their newly formed trade union to be registered under the Trade Unions Act of 1926, which Samsung was objecting to. So what is the issue? Workers at Samsung Electronics Limited at Sriperumbudur in Tamil Nadu, they went on strike, which lasted for 38 days. In fact, all the trade unions supported them. In fact, Central Industries Trade Union, they also supported them. Initially, the trade union associated with the DMK, with the ruling political party in Tamil Nadu, also supported them. But then the Tamil Nadu state government also tried to break this strike because it does not look well for the image of the state, because Tamil Nadu wants to position itself as the manufacturing hub in India. It wants to attract investments from abroad. It also has an ambitious target of making $3 trillion economy, whatever that is. So strikes by workers at industrial units does not look good for any state, because then it becomes difficult for that state to attract foreign investment. But be that as it may, this was one of the longest strikes in the recent years. Primarily, the strike was these workers, they wanted better wages, more humane working conditions, but most importantly, their demand was that our union, newly formed union, which is Samsung India Workers Union, should be registered under the Trade Unions Act 1926. For 17 years, Samsung was rejecting the demand of these workers to form the union. Finally, in June this year, the workers formed a union called Samsung India Workers Union. Now listen to me carefully. What is it that you need to know from this topic? Let's go back to 1920s when there was a strike at Binny Mills, again in Tamil Nadu, Madrasa as it was then called. So in Binny Mills, there was a strike. It was a strike by the trade union leaders. But then what happened? The owners of Binny Mills, they filed a civil suit against these trade union leaders. Because when you go on a strike, you basically stop the production, which basically negatively impacts this mill, the revenue generating capacity of this mill, which means this mill has incurred losses. Now I will recover these losses from these trade union leaders. And massive damages were sought from these trade union leaders, which obviously they could not pay because they're poor. In response to the strike in Binny Mills in 1920, a law was passed in 1926 called Trade Union Act. One of the important provisions of this Trade Unions Act is that there is immunity to the trade union leaders. Once a trade union has been set up, these trade union leaders will have immunity from any civil case, from any criminal case that can be filed, any civil case that can be filed. Because if you're agitating on behalf of the demands made by the workers, for that you cannot be held accountable. No civil damages can be sought from you. But for that, workers should not go on a strike. So collective effort of the workers should not happen. Collective strike by the workers should not happen. For that, if trade union leaders will negotiate on behalf of the workers, then these union leaders will not be held accountable for any civil damages. That is the beautiful provision in a Trade Unions Act. And under this Trade Unions Act, there is one officer known as the registrar. If there is a group of people belonging to an organization, belonging to a company, belonging to an industry, belonging to a factory, if they want to register a union, what they have to do, they have to approach the registrar. And this registrar has only one option: register this trade union. If the application is an order, now how can you say that this application is an order? If you have given in the application that this is going to be the name of our trade union, these are the members of the trade union, these are the honorary and the permanent members of the trade union, this is going to be how funds will be collected for this trade union, who will conduct the audit of this trade union, how this trade union can be dissolved, whether non-employees will be part of these trade unions. If everything is mentioned in this application, then this registrar has no other option but to register this trade union. So in June this year, when Samsung India Workers Union, when they decided to approach this registrar that please register our trade union, Samsung filed an application before the registrar saying don't register, which legal experts say registrar should not have accepted, because the only entity which can approach the registrar are the workers to form the union, to register a union. Company cannot intervene in this matter. But be that as it may, Samsung had two objections. What were these two objections? Number one, you should not use the name Samsung in this way. Don't call it Samsung India Workers Union. So we are objecting to the use of the word Samsung while registering this trade union. We have another objection. Outsiders are made members of this union. We are objecting to these two. Remove Samsung from the name because it does not bode well for the reputation of this organization, and outsiders should not be part of this trades union. And it is ironical. Why? Because Samsung is from South Korea. And in South Korea, Samsung employees have a trade union called National Samsung Employees Union. But in India, you're objecting to the use of this name, Samsung. Plus, the trade union, the employees of the workers of Samsung unit, they wanted to register this union under Trade Unions Act, not under Trademarks Act. For example, I cannot register a company with the name Samsung because then I am in the same business as Samsung. You will be confused. Who is the real Samsung? Will the real Samsung please stand up? So you are then competing with the business of this organization. Samsung has the trademark over this name. You cannot misuse it. But the workers were not in the business. They wanted to register under Trade Unions Act, not Trademarks Act. But even then, matter went to the High Court. Now we will have to wait and watch what will happen in the High Court. But from this topic, you need to understand another thing, the decline of trade unions in India. Trade unions, particularly in Tamil Nadu, used to be very, very strong and powerful. But all of this changed after 1990s when liberalization, privatization and globalization took place. How? Because after liberalization, labor laws were modified. Minimum Wages Act was diluted. To compete with China, for example, these organizations were given the power to hire and fire at will. Organizations were given the power that you can, or were given the option, or were given the liberty that you can hire contract workers. And these contract workers do not have the same standing as the regular worker. Because of liberalization, privatization, globalization, these organizations could shut down businesses without government approval, because previously you needed government approval to shut down a business, to shut down a unit. So all these aspects led to the decline of trade unions in India. So from this particular topic, you need to understand first, why were the Samsung workers protesting on strike in Tamil Nadu? It's because they wanted primarily their trade union to be registered. What is the process of registering this trade union? Why Trade Unions Act was enacted in the first place? Because of the Binny Mills case of 1920. What is the exception provided under Trade Unions Act to the trade union leaders? The registrar of the under the Trade Unions Act has no other option but to register the union. If the application for registration is in order, which means if the application clearly says what is the name of this union, who are the office bearers, how the executive members are appointed, who will conduct how the audit of these funds will be conducted, how this change of name can take place of this union, how this trade union can be dissolved. If everything is mentioned in the application, if the application is in order, the registrar has no other option but to register this union. Instead, the registrar accepted the viewpoint of Samsung, where legal experts say that Samsung should not have intervened in this case, or should not have been listened to by the registrar, because you don't have to listen to the organization, industry, factory. You have to just listen to the workers. If they wanted to register their union and the application is in order, you have no other option but to accept, but to register. And another case, another important aspect, why there is a decline of trade unions in India. These are the aspects that you have to take care of. Those who understood this topic say yes. Those who did not say false. Okay. Topic number 4, Junk Model Code of Conduct. Why we are picking this article? Because of an interesting column written by Professor Yogendra Yadav in Indian Express on the 29th of October, Junk Model Code of Conduct. Why? These are the views of Professor Yogendra Yadav. If you don't like these views, hold him accountable. Don't lynch me. Okay? What is Professor Yogendra Yadav arguing? Elections will be happening in Jharkhand and Maharashtra. And in both the states, Professor Yogendra Yadav says, violation of Model Code of Conduct has taken place. He says, you just look at the Model Code of Conduct, provision by provision, and then see that provision by provision, it is getting violated in the election scene. Model Code of Conduct, for example, says, if you have to criticize the policies of the political parties or their candidates, don't go personal. But that's what is happening. You can't be asking for votes in the name of religion or caste or language. But that is what is happening. You can't be making speeches which aggravate the tensions between communities, whether based on religion or caste or language. But that's exactly what is happening according to Professor Yogendra Yadav. In fact, Professor Yogendra Yadav says, he's a psephologist also. He was the one who, one of the rare individuals who projected or predicted the outcome of the 2024 Lok Sabha elections, although he was miserably wrong in predicting the outcome of the Haryana Legislative Assembly elections. But he's a psephologist, previously worked with Center for Society of Developing Societies. If you read the old NCRT books, he is one of the important members of NCRT. He used to be. And when, as a psephologist, he would go to the fields to check the mood of the electorate, to find out the opinion polls, exit polls. Although the limit for a candidate to spend in the election is 70 lakhs, 40 lakhs in smaller constituencies. He says, Yogendra Yadav says, that I am yet to come across a candidate who has spent less than 10 crore rupees. So candidates spend anywhere between 10 crore to 50 crore rupees. Paid news is no longer a joke. Paid news is rampant. And for that, he says, look at the report of the independent panel for monitoring Indian elections 2024. And this independent panel for the monitoring of Indian elections says Model Code of Conduct should be strengthened. Yogendra Yadav says don't strengthen it, junk it. Yogendra Yadav answers saying this may sound a knee-jerk reaction. This may sound a desperate overreaction. But this is what is needed. We need to junk Model Code of Conduct. Why? Because it is useless. And it is useless because it is not implemented fairly by Election Commission of India. And for that, we need the Election Commission of India with a spine, with willpower. Why? There was a time, because you would know that the very purpose of Model Code of Conduct is to ensure a level playing field, so that opposition and government, opposition candidates and the candidates of the ruling political party, they have an equal chance of winning the election. There is no undue advantage. That was the reason Model Code of Conduct was implemented. And in fact, there is no law which backs Model Code of Conduct, which gives a statutory backing to Model Code of Conduct, because after all, it's a voluntary innovation by all the political parties. All the political parties, they have voluntarily agreed that we will abide by this Model Code of Conduct. Although there is no law which codifies Model Code of Conduct. That's why there was a demand for a long time that we need to give statutory backing to Model Code of Conduct. In fact, Election Commission of India also asked for statutory backing to Model Code of Conduct, didn't happen. But then Election Commission of India says, we don't need statutory backing. Why? Because if we give statutory backing, The power to enforce will then be with the judiciary. How? Listen to me carefully. There are some provisions, most of the provisions in Model Code of Conduct, which are already covered in other laws. For example, Model Code of Conduct says you can't bribe voters. Bribery is a crime under Bharatiya Nyaya Sanhita, previously under Indian Penal Code. Model Code of Conduct says don't give any speech which incites or aggravates the differences between communities, whether based on religion, caste, language. That is also a crime under Bharatiya Nyaya Sanhita, previously Indian Penal Code. Model Code of Conduct says you should not use languages which are going to aggravate differences. You should not be asking for votes in the name of caste or language or religion. That is also an offense under the Representation of the People Act 1951. So Yogendra Yadav says majority of these provisions under Model Code of Conduct, they are already covered under the other laws such as Representation of the People Act, such as Bharatiya Nyaya Sanhita or previously Indian Penal Code. So why do we need Model Code of Conduct? Junk it. In fact, under Article 324, Election Commission of India has the power of superintendence, direction, conduct and control. You can do anything if you have spine to enforce free and fair election. But for that, we need Election Commission of India with a spine, according to Yogendra Yadav. He says, he asks, why then do we need a Model Code of Conduct? The first answer is, listen to me carefully. If there is an aspirant preparing for this exam who is very intelligent and religiously follows classes, takes tests, and this student is telling you, advising you that don't follow Frontline magazine, follow this magazine, would you listen to him or her? Yes. Because he has moral authority to tell you what to do, because you know he is honest. He is working, he's preparing thoroughly, religiously for this exam. Now there is an individual who prepares for this exam once and then disappears. Would you take his advice or her advice seriously? You won't. So if Election Commission of India censures a candidate that you should not be doing this, it invites public criticism. Election Commission of India has criticized a candidate, has censured a candidate. So previously it was thought that censure by Election Commission of India invites the wrath of the Election Commission, which doesn't go well with the public, and public will punish that candidate who has been censured by the Election Commission of India. Now Yogendra Yadav says if Election Commission of India's reputation is at stake, any censure given by Election Commission of India will not amount to moral sanction. So why do we need Model Code of Conduct? And second, if the purpose of Model Code of Conduct was to ensure level playing field so that the ruling party does not have an advantage, you just have to look at the conduct of the Election Commission of India, that it delays the announcement of election dates so that it favors the ruling political party. Again, not my words, words of Yogendra Yadav. And that is why Professor Yogendra Yadav says, other reason why we had Model Code of Conduct was courts cannot interfere in electoral matters because there is a bar. Article 329 says there is a bar on the interference by courts in electoral matters, which means during elections, if something happens, you can't go to the court. So you should go to a moral authority called Election Commission of India so that quick action can be taken. Yogendra Yadav says the decisions of the Election Commission of India, the adjudication of Election Commission of India is neither quick nor fair. During the 2024 Lok Sabha elections, Prime Minister Modi said something which critics argued violated Model Code of Conduct. So did Mr. Rahul Gandhi, violated some provisions of Model Code of Conduct. Election Commission of India, instead of sending notices to the Prime Minister and Shri Rahul Gandhi sent notices to the party presidents, JP Nadda and Mallikarjun Kharge. So Yogendra Yadav says the actions of Election Commission of India, the adjudication is neither fair nor quick. Nor quick in the sense. Association for Democratic Reforms has asked a basic question to Election Commission of India. What is that basic question? That there is a discrepancy. That votes polled through EVMs and votes counted by EVMs, there is a discrepancy. So votes polled through EVMs are less. Allegation. Votes counted by EVMs are more. In how many constituencies? Association for Democratic Reform says in 536 of the 543 constituencies, there is a discrepancy between the amount of votes polled and the amount of votes counted. Association for Democratic Reforms asked this basic question to the Election Commission of India. Why is there a discrepancy? Election Commission of India has not dared to reply, which means its adjudication is neither quick nor fair. But it seems that Professor Yogendra Yadav is dissatisfied with Election Commission of India, not with Model Code of Conduct. So maybe we still need Model Code of Conduct, but to fairly implement it, we need an Election Commission of India with a spine. But he does raise one interesting question, one important question. For example, when a commoner approaches a public official, asking public official to do his or her duty, the official says, I can't. Why? Because Achar Sanhita Lagu hai. Model Code of Conduct is in force. I can't do anything. So during this Model Code of Conduct, the public officials, they don't discharge their official duties and work for the betterment of the society because they have an alibi, they have an excuse ready that since Model Code of Conduct has come into the picture, we will not be working, which affects the ordinary people. So Yogendra Yadav says, for this reason, we just need some provisions of Model Code of Conduct to be inserted, amended into Representation of the People Act or Bharatiya Nyaya Sanhita, then we don't need Model Code of Conduct at all. This is the view of Shri Yogendra Yadav. But tell me, what is the answer to this question? Consider the following statements. Model Code of Conduct kicks in as soon as the election notification is issued by the Election Commission. During the period of election silence, the findings of the opinion polls cannot be broadcast. The basic purpose of the Model Code of Conduct is to ensure a level playing field in Indian elections. Which of the above statements is or are incorrect? You have 30 more seconds. Model Code of Conduct kicks in as soon as the election notification is issued by the Election Commission. This is incorrect. Model Code of Conduct kicks in as soon as election dates are announced by the Election Commission of India. Election notification is issued by President or the Governor. President in case of Lok Sabha elections, Governor in case of the state legislature elections. So the first statement is incorrect. During the period of election silence, the findings of the opinion polls cannot be broadcast. This is correct. Election silence is 48 hours from the end time of the polling. If the polling is today, it will end today at 6 o'clock in the evening. From 6 o'clock, go backwards for 48 hours. That's the period of election silence. During this period, opinion polls findings cannot be broadcast. This is correct. The basic purpose of the Model Code of Conduct is to ensure a level playing field in the Indian elections. This is also correct. That's the purpose, to ensure level playing field. Which of the above statements is or are correct? Two statements are correct. Right or wrong? Any confusion, anybody? Okay. Topic number 5, UP Madrasa Act. But for this, I need a suggestion from you. It's 10:30. There are two topics. The class is normally from 9 to 11. Right? So there is topic number 6, which deals with anti-defection law in Goa. That will roughly take about 15 minutes. Then there is this topic number 5, UP Madrasa Act, which will take close to 45 minutes to 1 hour. What do you want? You want this to be continued today, or I can record a separate lecture on UP Madrasa Act and will upload it tomorrow. What do you want? Record, no sir, continue, whatever suits you, continue, record, continue, record, continue, record. Okay, let's continue. Topic number 5, UP Madrasa Act 2004. But this judgment was given by the court this month, Anjum Kadri versus Union of India 2024. So this is the name of the case. What was the purpose? What was the issue? In 2004, Uttar Pradesh Board of Madrasa Education Act was passed. In 2024, Allahabad High Court declared that this law in its entirety is unconstitutional. Not just 1-2 provisions. The entire law is unconstitutional. Why? Because it violates secularism. And secularism is part of the basic structure of the Constitution. Not just that it violates secularism, this law also violates Article 21 capital A of the Constitution, which is right of every child in the age group of 6 to 14, that you have the fundamental right to get primary education. So this law violates Article 21 capital A as well. And this law violates Article 14 of the Constitution as well. So what Allahabad High Court said this year in 2024, that this UP Board of Madrasa Education Act is unconstitutional in its entirety. Why? Because it violates secularism, which is part of the basic structure of the Constitution. It violates Article 21 capital A. It violates Article 14, the right to equality. How? We will discuss it later. When this judgment was given by Allahabad High Court, one body called National Commission for the Protection of the Child Rights, it sent 2 notifications. Notification number 1 to Uttar Pradesh government, that UP government, now that Allahabad High Court has declared this law of 2004 as unconstitutional, what you should do, you should investigate all these madrasas and you should ensure that non-Muslim students who are studying in these madrasas, they should be given admission in educational institutions. This is notification number 1. Non-Muslim students. Another notification, it requested the center, that center, please direct all the states that you should withdraw recognition to all those madrasas which are violating Right to Education Act of 2009. So what are you saying? We are discussing Anjum Qadri versus Union of India 2024 judgment. In this judgment, Supreme Court upheld the validity of this law. Supreme Court said this law is constitutional with some exceptions, but this law is constitutional. Basically, Supreme Court negated the judgment of the Allahabad High Court because Allahabad High Court had said this law in its entirety is unconstitutional. In response to that, National Commission for the Protection of the Child Rights issued two notifications. One, to the UP government, that you should investigate these madrasas and you should ensure that non-Muslim students of these madrasas are given admission in government institutions. And another notification to the center, requesting the center that please direct all the states that you should withdraw recognition to all those madrasas which are violating the Right to Education Act of 2009. Both these notifications of NCPCR and this judgment of the Allahabad High Court was stayed by the Supreme Court. First stayed by the Supreme Court, saying we will first have to look at the validity of this law. Till that time, this Allahabad judgment will not come into force. We are staying it. And both these notifications of NCPCR, they are also stayed. This is the background. What is a madrasa? Madrasa, basically any school, any college, any institution which imparts education of any sort. It's an Arabic term, madrasa. Any institution which imparts education of any sort is a madrasa. And you can trace the origin of these madrasas in India to the Tughlaq rule. During the Tughlaq rule, we saw the mushrooming of madrasas in India. And these madrasas have basically two broad sets. Either we have maktabs or we have madrasas. What are these maktabs? These maktabs are linked to every mosque. So in every masjid, every mosque, there was a maktab associated with it where elementary education was taught. Elementary education. The Quran will be taught. The Hadith will be taught. Some basic elementary education will be taught. This was a maktab. Then madrasa was a institute of higher learning where Arabic would be taught, Persian would be taught. And during the Tughlaq rule and then again during the Mughal rule as well, Persian or Farsi used to be the court language. Urdu was also taught, Arabic was also taught, Farsi was also taught. So if these madrasas are the institutions of higher learning where Arabic, Urdu, Persian, Farsi is taught, and these languages are important languages to get jobs, to get administrative positions in Mughlaq and Tughlaq rule. So that means these madrasas had enough significance. But the significance of these madrasas diminished when colonial government came here, when the British controlled India, because they introduced English language. Because with the introduction of the English language, the significance of Arabic, Persian reduced significantly. Then came the independence. And after the independence, let's first focus on UP because this question relates to Uttar Pradesh. In UP, Department of Education of UP. Why this is important, I'll tell you slightly later. Department of Education of UP issued the Madrasa Education Rules of 1969. Why? So that these madrasas are brought under Education Department. Which means these madrasas, which are basically religious institutions, they are brought under the control of a secular Education Department. Understand? State government then framed some rules. UP non-government Arabic and Persian Madrasa Recognition Rules 1987. If you follow these rules, we will give you recognition. If you will not, we will not give you recognition. That means we will have to ensure that your buildings are of quality, your teaching staff has qualifications to teach, and if you are following these rules, we will give you recognition. Otherwise, we will not. So secular state is going to give recognition to a religious body, which is going to give religious education. Then, that's why I said this point is important. First, it was under education department. Then these madrasas, their management was transferred to minority welfare and Waqf department of the UP government. Initially under the Department of Education. Now they are under the Ministry of Minority Welfare of the UP government. And not just the UP government, in fact, central government also implemented area intensive and madrasa modernization program. Why? Because we want to encourage these madrasas, these maktabs, that apart from teaching Arabic or Persian or Urdu, you should be teaching modern subjects such as science, mathematics, English, Hindi, social studies. And these madrasas, they were also subsequently made part of the Sarva Shiksha Abhiyan as well. Why I am giving you these details is that these madrasas were not operating in isolation. There was a government regulation. There was a government control. There was a government recognition. And in fact, government would fund these madrasas as well. If you look at these madrasas, in UP specifically, there are 560 madrasas which are funded by the state. Then there are thousands of madrasas which are not funded by the state. In fact, the annual budget of the UP government for these madrasas is 1096 crores, which supports the salary of the teaching and non-teaching staff of these madrasas. Books are also provided. Midday meals are also provided. In fact, in some of these madrasas, the government is also implementing ITIs, industrial training programs, where apart from where you are also taught welding, carpentry, and other skills. So there is a close-knit connection between the madrasas and the state. State is funding some of these madrasas which are obeying the rules of recognition. 1096 crores as salary for teaching and non-teaching staff of these madrasas. Food is provided, midday meals are provided, books are provided, stationery is provided, school uniforms are provided. And in some of these madrasas, industrial training is also given in the fields of welding, in the fields of carpentry as well, so that skill development takes place. Further, what is the academic education in these madrasas? We can broadly divide them into 4 levels. What are these 4 levels? Tathania, which is equivalent to primary education, class 1 to 5. Then Fokwania, equivalent to middle schools, class 6 to class 8. Then Molvi or Munshi, equivalent to class 10th. Then Alim, which is equivalent to class 12th. Which means if you are a student of a madrasa and you have completed Molvi or Alim, which means you have completed 10th and 12th. Which means then you can go for graduation degree. You can then go for post-graduation degree. And it is not only UP government recognizing it. It is central government also which is recognizing the Molvi and Alim degrees awarded by the certificates, not degrees, certificates awarded by these madrasas. Such a committee, which was set up by the government to look into the plight of the Muslims in India, It said that by looking at all these madrasas, majority of the students are studying in these madrasas only till middle school, only till 8th standard. After that, they go to regular schools, where regular private or government schools. When it comes to these madrasas, theology is taught. Whether it is Shia theology or Sunni theology, Arabic literature is taught, Urdu literature is taught, Persian literature is taught, Hindi literature is taught. And then there are some optional subjects: mathematics, science, social science, medicine. These are optional subjects. But then there are some madrasas which award degrees such as Fazil, which is equivalent to undergraduate and postgraduate degrees. Kamil, Fazil, these degrees are also awarded. So equivalent to undergraduate course and postgraduate course, which basically means that if there is a requirement for an Urdu teacher or an Arabic teacher or a lecturer or a Persian lecturer, even if you have not done masters in Arabic or Farsi or Urdu from a recognized university, but you have done it from a madrasa, these degrees awarded by these madrasas, such as Kamil and Fazil, you are eligible to get these jobs as well. And the most important aspect of this UP Board of Madrasa Education Act of 2004 was the constitution of a board. What will be the function of this board? To prescribe course of instructions, textbooks, and instructional material that will be used for all these levels, including Kamil and Fazil. Kamil for UG degree, Fazil for PG degree. Prescribe course books, grant degrees, diplomas, certificates, everything will be the job of this board. And who will be the members of these boards? Only Muslims. And these members may not be academic experts, but these members may be theologians, experts of Islamic laws, Islamic jurisprudence. Then how did this case reach the court? One part-time teacher of one of this madrasa approached the Allahabad High Court. My lord, I have a case. Said, what? I should be given the same salary as a permanent teacher. Why am I given less salary as compared to a permanent teacher in a madrasa? There should be no discrimination against me. Allahabad High Court is surprised. That forget about this question whether you should be given parity in terms of salary with a permanent teacher. But what is happening here? There is a madrasa board under this law which only has Muslims. Madrasa education is the only education in UP which is under the Minority Welfare Department. Even if madrasa is a minority institution, and minority educational institutions have constitutional protection under Article 30. But what about other minority institutions related to Christians or Jains or Buddhists? They come under Ministry of Education, Department of Education. Only madrasas is under minority welfare. The board only has Muslims and no other person. And these board members may not be experts in their fields, but they may be experts in Islamic laws. So the single bench of Allahabad High Court, they said, we have to look at the validity of this law. Then we will decide your question. Then came others who also questioned this law. Other writ petitions were filed. Said, my lord, what is happening? Said, what? Article 28. Listen to me carefully. Can religious instruction be imparted in a school, in an educational institution, which is funded by the state? Here there is religious instruction being imparted. That too in these madrasas which are funded by the state. The state is secular. How can the secular state provide funding to an institution which is making it mandatory to have religious instruction in place? All these raise troubling constitutional questions. And in 2024, Allahabad High Court said this law in its entirety is unconstitutional. Why? Because state legislature, number one, has violated secularism, and state legislature does not have the competence to pass this law. Why? Because University Grants Commission, it only has the power to award degrees, whether it is bachelor's degree or post-graduation degree. But here these madrasas are awarding degrees, diplomas in the form of Kamil, Fazil. UGC cannot, except UGC, no other entity can award degrees. As such, this law is unconstitutional. But then matter went to the court. Matter went to the Supreme Court, as I told you. And now let's see how the Supreme Court looked at this issue and how Supreme Court said that this law is constitutional. Not in its entirety. There are some aspects which were declared unconstitutional. Let's focus on that. But first, let's understand what High Court said, Allahabad High Court. Allahabad High Court said that this Madrasa Act in its entirety is unconstitutional. And it directed the state government that all these students who are studying in these madrasas, they should be accommodated in regular primary schools, high schools. And you should, if there are no seats, you should provide additional seats so that nobody can be deprived. No students who is studying in these madrasas can be deprived of their fundamental right to education under Article 21, capital A of the Constitution. No child in the age group of 8 to 14 is left behind. Now this judgment of the court, Allahabad High Court, was challenged before the Supreme Court. On one side were the petitioners who said, no, this law is constitutional. What were their arguments? On the other side were the critics of this law who said, no, this law is unconstitutional. What were their arguments? We have to understand both the arguments. Let's first understand the arguments of those who said this law should not have been declared unconstitutional. This is a constitutional law. They said, state legislature has the competence to pass this law. Why? Because under Article 246, which talks about schedules of the Constitution, 7th schedule, which talks about distribution of the legislative subjects. In that, there is list 3, which is concurrent list. Education comes under concurrent list. So both center as well as states, they have the power to regulate education. Okay. But how do you regulate madrasa education? That's the question. Madrasa Act principally deals with regulation of madrasas, but concerning their curriculum, instruction, standard of education, how the examination is conducted, what will be the qualifications of those who apply for the teaching jobs in these madrasas. These madrasas are minority educational institutions under Article 30. But that does not mean that state cannot regulate it. State can regulate the secular functions related to a minority educational institution. What? Under Article 30, Constitution says all minorities, whether based on religion or language, they have the fundamental right to establish, manage, and administer educational institutions of their choice. But even then, the state can regulate the quality of teachers, secular functions related to it. So one, UP legislature has the competence to enact this law. Why? Because education is in concurrent list. Second, even if these madrasas are minority educational institutions, But secular functions related to these minority educational institutions can be regulated by the state. Argument number 2. This is the most interesting argument. In S.R. Bommai, Supreme Court said secularism is part of the basic structure of the Constitution. Allahabad High Court said secularism has been violated. As such, this law is unconstitutional. Petitioners say Article 25 to 30 secures the rights of linguistic and religious minorities. How? Article 25 says, I have the fundamental right to practice my religion, profess my religion, propagate my religion. Article 26 says, I as a religious denomination, I have the right to establish, manage and administer institutions of my choice. Article 27 says, nobody shall be forced to pay taxes, the proceeds of which will be used for the promotion of any one particular religion. Article 28 prohibits religious instruction in government schools, in schools funded by the state, but not in minority educational institutions, which are established by the minorities. Article 29 talks about the cultural rights. Article 30 talks about the rights of the minorities to establish, administer educational institutions of their choice. And in fact, the state cannot discriminate. When the state is granting funds, the state cannot discriminate whether it's a minority-run institution or a community or a school run by the majority. It has to provide funds. So just because UP is funding these madrasas, that does not mean that these madrasas cannot teach religious education, cannot impart religious education. Because after all, they are doing this to protect their constitutional right under Article 30. Most interesting point. There is a difference between religious instruction and religious education. Religious instruction is if you are forcing people to pray namaz or do puja, or you are forcing kids to chant religious hymns or to be part of the Sunday mass prayer. That is religious instruction. Then there is something called religious education, where you are teaching different religions. And when you are taught different religions, you become sensitive to each other's religious philosophy. You are able to tolerate each other. That's the job of education. So the petitioners, very cleverly, they're trying to make a distinction between religious instruction and religious education. Religious instruction may not be imparted. You can't make it compulsory. You can't force it. But religious education can be given. Article 21A has been violated. That was the demand of the petitioners. There is a fundamental right for all the children in the age group of 6 to 14. When this Madrasa Act was passed, and when this Right to Education was passed, Right to Education Act 2009, it specifically says that this right to education does not apply to madrasas. The petitioners argued that since this Right to Education Act explicitly states that this law does not apply to madrasas, it violates secularism. And it violates Article 21 capital A of the Constitution. Those who defended this law, they say the law enacted by the state in pursuance of Article 21A cannot violate fundamental rights of minorities under Article 30. So if Article 30 gives a right to every minority to establish, manage and administer educational institutions of their choice, this is Article 30, which is more sacred than an ordinary law passed by the Parliament in 2009 called Right to Education Act. Even if this Right to Education Act was meant to implement Article 21 capital A, which again is a fundamental right, but this ordinary law cannot violate Article 30, which is more superior. And the prayer of the petitioners was, my lord, if you strike down this Madrasa law as unconstitutional in its entirety, then what will happen? It will affect the future of 12 lakh students who are studying in different madrasas in UP. And it will have an impact not only on UP, but in Assam, in other parts of the country where there are madrasas. And it will basically mean that these 12 lakh madrasa schools, 12 lakh students who are studying in madrasas, they will have to be shifted to other schools. Then what will happen to these madrasas? These madrasas will have to be shut down. When these madrasas will be shut down, don't you think it will affect Article 30, which is the right of a religious minority to establish, manage and administer religious institutions, educational institutions of their choice? On these grounds, we are praying that this law is constitutional. Don't strike down this law. Why don't strike down this law? Because legislature of UP has the competence to pass this law. This law does not violate secularism. In fact, it strengthens secularism, according to petitioners. This law, it does not violate Article 28 because we are providing religious education, not religious instruction. Article 21A has not been violated. And what will happen to the lakhs of the students who are studying in these madrasas? Then these madrasas will have to be shut down. Then what will happen to Article 30, which is the fundamental right under the Constitution? Then a counter was filed by the other side, those who challenge the validity of this law. They say, question number 1, this UP Board of Madrasa Act of 2004, why does it not make the teaching of secular subjects compulsory? When you don't do that, you are basically regulating religious instruction. When you are regulating religious instruction, that too belonging to a particular religious community, you are violating secularism. What is taught in these madrasas? Theology, Arabic literature, Urdu literature, Persian literature, Hindi, English, and then there are optional subjects, mathematics, science, social science, medicine, so on and so forth. So you are basically regulating what? Religious instruction. That too belonging to a particular religious community. You are not regulating secular education related to math, science, English, so on and so forth. Question number 2. Can state which is secular fund an educational institution for imparting religious instruction? And that too give recognition to this religious instruction. One, you are giving funding to these madrasas that you promote religious instruction. And then you regulate them as well. You recognize them as well. You fund them as well. This goes against the core concepts which is mentioned in the preamble, which is secularism. Third, India is a secular republic. Article 21 capital A, which talks about fundamental right to primary education. Article 25, Article 28, Article 38, Article 41, all talks about the principles of secularism in India. And secularism means distant from the religion and state are different, separate from each other, distant from each other. But by passing this law, you are regulating religious instruction, which goes against, militates against the concept of secularism. But the most important point, my lord, in list 3, in concurrent list, there is word education. you have to construe this term education to mean secular education. Education cannot include religious instruction. The state legislature has the power only to regulate educational institutions, but it does not have the power to regulate institutions which are imparting religious instruction. Further, UGC Act, only UGC University Grants Commission has the power to grant degrees and diplomas. How can these madrasas grant Kamil Fazil degrees which are equivalent to graduation and post-graduation? That is beyond the scope of state legislature, because that's the power given to the parliament. Because UGC can decide which other entity can award degrees. State legislature cannot decide, because that's the power, that's the competence of the legislature, which is the center, which is the parliament. And we are not talking about secularism only. We are talking about these kids who are enrolled in these madrasas. What are you talking about them? Are you not depriving these kids who are taught in these madrasas from the benefits of the holistic education by making them confined to religious education only? Is that not violative of their Article 21 capital A? Is that not violative of their 21, which is right to live with dignity? Because after getting these madrasa degrees, they are not eligible for other professional courses. So you are depriving their dignity. Not just that. Through this model, you are creating two different classes of citizens. The first, who receive secular mainstream education, those who are taught in government schools, other private schools, and those who receive religious instruction. And they can't even attempt to adopt professions which are easily available to the citizens of the first class, first students. This way, you are violating their dignity, which is under Article 21. You are violating their freedom of speech and expression, their thought, which is under Article 19. Now comes the judgment. Supreme Court said, number one, madrasas are established by Muslims, minority, which comes under Article 30. Which means Article 30 says every minority, whether based on religion or language, they have the fundamental right to establish, manage, and administer educational institutions of their choice. So first, these madrasas are minority educational institutions. Constitution further says, while providing funds, the state shall not discriminate while granting funds, whether this is a minority educational institution or not. That's mentioned in the Constitution. Article 30, according to Supreme Court judgment, it secures equal treatment of majority and minority institutions. And it preserves secularism. How? By allaying the apprehensions that there will be interference by executive and legislature in matters related to religion. In matters related to religion, we will not interfere. But if there is a right of an individual to practice religion, the secular part of the religion can be regulated by the state. What is that secular part of the religion? What should be the qualification of the teachers? What should be the kind of the infrastructure of these madrasas? That can be regulated by the state. And for that, if UP is passing a law, it is constitutional. So yes, if it is on the basis of Article 30, then yes, this law is constitutional. Okay, sir. Testing the validity of a statute for violating the basic structure of the Constitution. This is the most important part of this judgment. Constitutional Amendment Act has been passed. That Constitutional Amendment Act can be challenged on the grounds that it violates the basic structure. But can an ordinary law be challenged on the grounds that it violates basic structure? That's the critical question. If you understand this topic, if this concept, you have understood this topic. Suppose Constitutional Amendment Act has been passed. Let's say NJAC, 99th Constitutional Amendment Act. That can be challenged on the grounds that it violates basic structure. But can an ordinary law be challenged on the grounds that it violates basic structure? Supreme Court in Keshavananda Bharati case said there is something called basic structure which no Constitutional Amendment Act can snatch. So it was in this Keshavananda Bharati case that Supreme Court propounded the doctrine of basic structure. Right or wrong? In SR Bommai case, Supreme Court said secularism is part of the basic structure. Right or wrong? Right. What does Article 13, Clause 2 say? All the laws, if the state enacts a law which abridges or dilutes a fundamental right, that law is unconstitutional. So you can challenge a law on the grounds that it violates fundamental rights. It violates any provision of the Constitution. Article 246. Look at the beauty. It defines the scope and limitations of the legislative competence. What is the legislative competence? For example, I am Karnataka legislature. I am enacting a law on money, currency. Can I enact this law? No. Why? Because it is not in my competence, within my competence. Why? Because this is not part of the state list. Why? Because this is part of the union list. That means on currency, who has the power to make law? Center, Parliament. Supreme Court said a law, an ordinary law, can be declared unconstitutional only on two grounds. If it is beyond the legislative competence of that legislature. If Parliament enacts a law which is under state list, unconstitutional. If state legislature enacts a law which is under union list, unconstitutional. So a law passed by the legislature can be declared ultra vires only on the grounds, number one, if it is not within your competence, and second, if it violates part 3, which is fundamental rights, or any other part of the Constitution. Why? Because this we can trace to Article 13, Clause 2. Because Article 13, Clause 2 says, the state shall not make any law to abridge fundamental rights, to modify fundamental rights, to delete fundamental rights. But can an ordinary law, can an ordinary statute, such as UP Madrasa Act, be challenged on the grounds that it violates basic structure? No. Who said this? Supreme Court. Why? Supreme Court gave a reason. Supreme Court said this concept, and in fact this is something which was told for the first time by Justice A.N. Ray in 1970s, that you can't test an ordinary law on the grounds that it violates basic structure. Because if you do that, then you are rewriting the Constitution. Why? Because these concepts of basic structure such as secularism, such as democracy, such as federalism, they are vague. What is federalism to you? That's why when I teach students in the live classes, I tell them in the first class itself, what is unitary and federal constitution? I tell you the definition of a unitary constitution. But then when we discuss federal constitution, I tell you that there is no definition. Why? Because such a definition does not exist. What is secularism to you in US, in France, in China, in India? Varies. What is democracy? Varies. So all these terms, all these concepts, although they are part of the basic structure, but they are also undefined concepts. And if you are basically giving power to the courts to strike down an ordinary law on the grounds that they violate basic structure, you are basically rewriting the constitution. Yes, there are provisions of the constitution which pertain to secularism. For example, law cannot violate Article 25. Law cannot violate Article 26. Law cannot violate Article 30. But you can't say this UP Madrasa Act is violating secularism, which is part of the basic structure. As such, it is unconstitutional. No. Because an ordinary law can be challenged on only two grounds. Number one, did the UP legislature have the competence to enact this law? Number two, did this law violate Part 3 of the Constitution or any other provision of the Constitution? Fundamental rights or any other provision of the Constitution. That's it. You cannot challenge an ordinary law on the grounds that it violates basic structure. You can challenge a constitutional amendment on the grounds that it violates basic structure. That's the difference. Now, can a secular state regulate a minority educational institute? Minorities have the right to administer educational institutions of their choice, right? Which means they have the right to constitute the managing or the governing body. They have the right to appoint teachers. They have the right to admit students from their own community. That's what St. Stephen's judgment of 1992, Supreme Court said, minority educational institutions, they can admit, they can reserve 50% of the seats for their own community. That's the right under Article 30 given to these minority educational institutions. However, this right is not absolute. You can administer, look at the point, you can administer an educational institution of your choice, but that does not mean you can maladminister. For that, the state can interfere to see if the quality of teachers are good. The state can regulate to see if the quality of the infrastructure is good. The state can interfere to ensure that the standard of education provided to the students are good. And for that, it can regulate these minority education institutions. And that is what UP is trying to do through this law. Hence, it is not unconstitutional. Further, Justice Chandrachud, the Chief Justice of India, he said, when we look at this law, what is mentioned in the objects and reasons of this law? Because whenever a bill is introduced in the legislature, apart from the bill, there is a statement of objects and the reasons why we are bringing this law, why we are bringing this bill. That's also passed. That's also introduced. And in that statement, it is indicated that we are bringing this law because there is difficulty in running madrasas. That is why we need to bring this law. That we want to improve the merit of the students. We want to make facilities available to them so that these facilities are of required standard. Do you know what this does? It ensures further substantive equality. Because when we look at equality, we have to look at the outcome as well. If you are passing a law, what is the outcome of that law? If through this law, the outcome is that for Muslim students, the quality of education is enhanced, the quality of teachers is enhanced, the quality of infrastructure is enhanced. For these Muslim students, you are basically providing equality of outcome, which is substantive equality. So this law of UP furthers substantive equality. Now, important thing that the court had to understand was what is going to be the interplay of Article 21A and Article 30. What is Article 21 capital A? Free primary education as a fundamental right for the kids belonging to the age group of 6 to 14. Right or wrong? Right. Article 30 is for minority educational institutions. A Right to Education Act of 2009. It explicitly says that this right to education does not apply to madrasas. Supreme Court said what this basically means is that this right to education, which is a law to give effect to Article 21, this Right to Education Act of 2009, which is an ordinary law, we can't say that this ordinary law will have superiority over the rights under Article 30. So it is Article 30 which will prevail over Right to Education Act. But there is one aspect of this law which is unconstitutional. And what is that? When it comes to entry 66 of the union list, and under union list, that is the power of the that's the power of the parliament. It says coordination, determination of standards in institutions for higher education or research, scientific and technical institutions. That's the power with the parliament. So when state legislature passes this law, and through this law, you are trying to give power to madrasas to grant degrees in higher education of Kamil and Fazil. This is unconstitutional because they are in conflict with entry 66 of list number 1, which is union list. This aspect is unconstitutional. Further, doctrine of severability. Here is a patient. One hand has malfunctioned. There is poison. There is some issue. Does that mean you kill the entire individual or you sever the hand? You cut the hand. You cut the hand so that you can save the rest of the individual. Supreme Court is saying Allahabad High Court has erred. It should not have declared the law in its entirety as unconstitutional. It should only have severed those aspects which are unconstitutional. For example, allowing madrasas to grant degrees, Kamil and Fazil degrees. It should have severed that part and the rest of the law should have been declared constitutional. But Allahabad High Court had said, since this law violates basic structure, which is secularism, so we don't have to talk about doctrine of severability because in its entirety, the law is unconstitutional. But Supreme Court disagreed. Supreme Court said, no, the entire law is not unconstitutional. Only that aspect of the law which empowers these madrasas to give Kamil and Fazil degrees, which is in contravention to the UGC Act, which comes into the domain of the parliament. As such, that aspect of this law is unconstitutional. This is the UP Madrasa Act. And I think I took close to 50 minutes for this topic. If this topic is clear, let me know. Yes, Antra is right. That's the remark of the Chief Justice. If you are declaring the entire law as unconstitutional, that is throwing the baby out with the bathwater. Let's stop here. If you want to leave, good night. But I will finish this topic 6. Now that we have extended, let's extend a bit further. Okay? Okay. In Goa, the Legislative Assembly has 40 MLAs. In 2017, when the election was conducted to Goa Legislative Assembly, some members got elected on a Congress ticket to Goa Legislative Assembly. But then, as is the norm, these Congress MLAs jumped the ship, switched to the BJP. 10 of the 15 MLAs of the Congress, they jumped ship and joined the BJP. Matter went to the Speaker under anti-defection law. Speaker said they will not be disqualified. Speaker was asked why. Speaker said this is an exception because two-third merger has taken place. What is this two-third merger? If two-third of the members, they decide to merge with another political party, neither these two-third members will be disqualified, nor the members who are left, nor the other one-third members. Matter went to the Bombay High Court. Bombay High Court in 2022 said, Speaker is right. Because there is a paragraph 4 in anti-defection law which says two-third merger. So if two-third of the legislature MLAs, members of the legislature party, they have merged with another political party, it doesn't come under anti-defection law. And at that time, PDT Achari, who was the former Secretary General of Lok Sabha, he wrote an article in Indian Express saying this judgment of Bombay High Court will open the floodgates of defection. And perhaps it did. Now in 2022, when again elections were held to Goa Legislative Assembly, 11 MLAs belonged to the Congress party. Of that, 8 MLAs shifted to the BJP. Matter went to the Speaker. Speaker, sir, please disqualify them. After 2 years, because this petition was filed in 2022, after 2 years in 2024, now the Speaker is giving a verdict. Speaker says, I am not going to disqualify them. Why? Because this is two-third merger, which gets protection under anti-defection law. Congress is saying we will approach the Supreme Court. Tariq pe tariq pe tariq. But the point is, what is the legal expert's view on this? Listen to me carefully. It is two-third merger. It is not two-third split. Prior to 91st Amendment to the Constitution, there was a provision in anti-defection law called one-third split. What is that one-third split? If there are 30 members belonging to my political party in a house, and if 10 or more defect, these 10 will not be disqualified. So that used to be called one-third split. Mr. Vajpayee was the Prime Minister, Constitution was amended, 91st Constitutional Amendment Act was passed in 2003, and this one-third split was removed from anti-defection law. That is split. This is two-third split. Now it's not one-third splitting, it's two-third splitting to another political party. When one-third is not allowed, two-third also is not allowed. Then what is allowed is two-third merger. So there is a difference. What is the merger? For example, there is Janata Dal United and there is RJD. Janata Dal United of Nitish Kumar. RJD of Lalu Prasad. JDU has MLAs. It has MPs. RJD has MLAs. RJD has MPs. But if these two political parties decide to merge, not every member of RJD is part of the legislature as an MP or an MLA. Not every office bearer of JDU is member of legislature, either MLA or an MP. So if organizationally these two organizations decide to merge, for example, RJD merges with JDU or JDU says, I will give up my identity, all our people will be part of the RJD. So the combined entity will now be called RJD. What will happen to the JDU MLAs, JDU MPs? They will not be disqualified if 2/3 of these MLAs or MPs accept this merger. So first, this 2/3 merger would mean merger of political parties. This merger of political parties should be supported by 2/3 of their legislators as well. That will complete merger. So 2/3 split is not allowed. This is what constitutional experts say. Sir, is this the case similar to the case of Shiv Sena or Nationalist Congress Party in Maharashtra? No. Why? Because in that case, when Eknath Shinde rebelled, when Ajit Pawar rebelled, they did not say we merge with the BJP. They said we are the real Shiv Sena, we are the real NCP. So they claim parties. They don't say we merge our parties with other political party. This time they are saying we are merging with the BJP. This is also pending before the courts. This split of NCP and Shiv Sena is also pending before the Supreme Court. Let's see what the court will have to say on this matter. So from this Goa anti-defection law case, which was in the news in this period, you need to understand the difference between merger and split. Split is not allowed, merger is allowed. But what is happening here is not merger, it's split. Ideally, it should be struck down by the courts, and ideally these MLAs should be disqualified. Okay? Sir, if we say merger, then how can defected MLAs can carry party name and symbol? Is it merger means they are part of the new party? Ajit, merger in this case means that these 8 MLAs of the Congress, they are now part of the BJP. So their symbol is the lotus. In case where two factions, they claim that we are the real political party, matter is decided by Election Commission. Who gets the name of that party? Who gets the symbol? In both these cases, Election Commission decided that Ajit Pawar is the real Shiv Sena, Ajit Pawar is the real NCP, Eknath Shinde is the real Shiv Sena. Okay? Okay, answer this question. Consider the following statements regarding the 10th schedule of Indian Constitution. A member of a house belonging to a political party stands disqualified if he is expelled by his political party. Supreme Court cannot invoke Article 142 in disqualification petitions. Only a member of a house can file a disqualification petition before the Speaker, while a non-member can approach the courts. Which of the above statements is or are incorrect? Let me know the answer. You have 1 minute to answer. A, B, A, B, A. And when you are saying only two, also mention which are these two. Which of the above statements is or are incorrect? A member of a house belonging to a political party stands disqualified if he is expelled by a political party. Incorrect. A member of a house belonging to a political party is disqualified if he voluntarily resigns, if he joins another political party. The law is not clear what will happen to the person who is expelled by the political party. That is why we call such a person as unattached member. So you are still part of the House, but you're not attached to any political party, which means you're not disqualified. So this statement is incorrect. Supreme Court cannot invoke Article 142 in disqualification petitions. Incorrect. What is Article 142? Supreme Court can give any order so as to give complete justice. Couple of years ago, one Congress MLA in Manipur defected, joined the BJP, was appointed as the minister. His name, T. Shyam Kumar. He was appointed as a forests minister by the N. Biren government in Manipur. The speaker was asked to disqualify. The speaker did not. Matter went to the Supreme Court. Supreme Court gave time to the speaker. Gave, I think, 4 weeks time to the speaker to take the decision. After that, the speaker is not taking the decision. The speaker is asking for 10 days. Supreme Court says, okay, take 10 more days. After that, the matter is resuming in the Supreme Court. Speaker has still not taken any action. The speaker is asking for more time. This time, a 2-judge bench of the Supreme Court, headed by Rohinton Fali Nariman, says enough is enough. Used its plenary power under Article 142. Plenary power means a power which cannot be restricted by executive. That means government cannot restrict Supreme Court from using Article 142. And Supreme Court invoked Article 142 and stripped T. Shyam Kumar of his ministryship. Told him not to enter Legislative Assembly and asked the Speaker to decide this matter quickly. And then Speaker gave the decision, T. Shyam Kumar was disqualified. So even in disqualification petitions, Supreme Court can invoke Article 142. Only a member of a house can file a disqualification petition before the Speaker, while a non-member can approach the court. Incorrect. See, 3 statements are incorrect. What is this third statement? In 2013, there were 4 MLAs from NCP in Odisha Legislative Assembly. All the 4 MLAs joined the BJD of Naveen Patnaik. Mr. Utkal Kesri Parida, who was the head of the NCP in Odisha, he approached the Speaker. Can you please disqualify them? Speaker said, I will not accept your petition. Why? Because you're not the member of the House. Because according to the rules at that time, only the member of the House could have filed a disqualification petition before the Speaker. Mr. Parida approached the Supreme Court. Supreme Court said, no. Any voter has a locus standi. Any voter can approach the Speaker and file a disqualification petition. You don't have to be necessarily a member. That was the judgment of the Supreme Court in 2013. And it was in this Manipur judgment that 2-judge bench of the Supreme Court, headed by Rohinton Fali Nariman, asked the Parliament that you should reconsider whether you will entrust this power of disqualification to a Speaker who belongs to a political party. Because we don't have a system such as England where once a Speaker, always a Speaker. The Speaker belongs to a political party, and as such, the actions of the Speaker, they're partisan, biased in favor of the political party to which he or she belongs. So should these anti-defection law petitions, 10th schedule petitions, be entrusted to a Speaker who continues to belong to a political party? That's the question. And that's why this mains-based question, should disqualification petitions under the 10th schedule be entrusted to a Speaker as a quasi-judicial authority when such Speaker continues to belong to a particular political party? Suggest a suitable alternative. What is the suitable alternative? Either follow what is followed in England, once a Speaker, always a Speaker. Or give an alternative, suggest a time period within which the speaker should have to take a decision, or give this power of anti-defection law to an external body headed by retired CJI or retired judge of the Supreme Court or the retired Chief Justice of a High Court, so that this external body, which can be either a constitutional body or a statutory body, mostly a constitutional body, this body should be headed by a retired judge of the Supreme Court or the retired Chief Justice of a High Court. They should decide, instead of speaker, whether disqualification, whether anti-defection law petitions are to be accepted or rejected, or give time period to the speaker that within 3 months you have to take this decision. Or just like is followed in England, once a speaker, always a speaker. That's something that needs to be incorporated so that we can strengthen this anti-defection law. That's about it from today's UCAN session. If you have further questions, please let me know. If not, then good night. See you next time with another edition of the UCAN session. And if you have understood all the topics that we covered today, please let me know in the comment section. And don't forget to like this video as well. If you have further questions, either you can ask me in the Telegram channel, or you can post it in the comment section after the live stream ends, and I will personally respond to your questions. Quasi-judicial means it's not entirely judicial body. It's a mix. It's the body of the legislature, but takes a judicial decision, decides whether you should be disqualified or not. The link to join the Telegram channel is provided in the video description. Good night. See you again. Till then, have a great time. All the best. Bye-bye.